Thank you, Mr. Chairman. I'm pleased to express my support for the good work Chairman Coward has been done and the subcommittee have done on this bill. This amendment, which I offered with my colleagues Rep. Bill Huizenga and Rep. Bill Flores, aligns attorney fee award limits for Endangered Species Act lawsuits with award limits for other lawsuits against the federal government established by the Equal Access to Justice Act. The Equal Access to Justice Act generally limits the hourly rate for awards of fees to prevailing attorneys to a reasonable $125 per hour. However, no such fee cap exists under the Endangered Species Act. As a result, ESA litigants are being awarded sums in many cases in excess of $600 per hour. The Equal Access to Justice Act was not intended as the extraordinary access to taxpayer dollars for environmental attorneys. Indeed, we heard one of my colleagues a minute ago talk about sue and settle. According to the GAO, the Department of the Interior paid out over $27 million in attorney fees between 2001 and 2010. 21 million of the 27 of those payments were for Endangered Species Act lawsuits, many of them settled with no court finding against the litigants to have prevailed on the merits of the case. No finding. Mr. Chairman, it's time we close this loophole that enables excessive payouts to groups that have made a business of suing the federal government. There is simply no reason that one sort of lawsuit, a type commonly undertaken by entities solely engaged in continuous litigation against the government, should be paid more than any other. Representative Huizenga sponsored a measure addressing this issue last session, which was passed by the Natural Resources Committee, and I urge your support, which would be very much appreciated, including people like my daughter, whose birthday it is tonight, so they have a chance to be in business and not have these extraordinarily high fees. Mr. Chairman, I thank you and reserve my time.
The gentleman reserves.